Hello everyone and welcome to today's Mondac webinar in association with Chancery Law Corporation, who will be exploring how to manage complex construction arbitration in Singapore. My name is Dan Sampaio and I'm joined by a brilliant speaker to take us through today's discussion. Tian Luh is the Director of Chancery Law Corporation. Tian Luh specialises in providing legal services primarily relating to infrastructure, construction and engineering matters, advising on all areas of infrastructure, engineering and construction contracts, including drafting contracts, dispute resolution and insolvency matters. He also undertakes dispute resolution work in respect of corporate and commercial matters. Tian Luh has a particular expertise in claims arising out of the Building Construction Industry Security of Payment Act 2004. He is also experienced in arbitrations under various institutions, regimes such as the SIAC, ICC and ICSID. Before I hand over to Tian Luh to begin today's webinar, a quick housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right hand side of your page, and Tian Luh will endeavour to answer as many of those questions as possible during the Q&A session at the end of the webinar. It's now my pleasure to hand you over to Tian Luh to begin. Thank you. And I think, Tian Luh, what we'll need to do is take back control quickly from you and hand it back to you and select the other screen and you'll be able to share your presentation.
Okay. Whoops. Are we in it? Yes.
My apologies.
Okay. Welcome everyone. And let me see. Okay, my name is Tian Luh, and today I'm here to share with you some. Can anyone see the screen? All good.
We're seeing the other side of the presentation at the moment. You'll need to.
Apologies. I will. Okay.
Thanks, Tian Luh. What we'll need to do, Tian Luh, is
yes.
So our producer will hand over control to you now.
Okay.
Just before you click share screen, if you select on the drop down the second screen with the presentation on.
Okay, I will do that. Wait, gosh.
What I suggest we do, Aaron, our producer, if you share your screen, please, with the slides, and we'll move forward like that. Thank you.
Okay.
Thank you very much. We can see your slides now, Tian.
Oh, yes.
Very happy to let you start.
All right. Okay, today I hope to share some thoughts and experience on managing construction arbitration in Singapore. Although the focus is on Singapore, a lot of the principles and experience that I will share will hopefully be relevant to any jurisdiction. Now, so as in the construction industry, we often experience disputes in almost every project. Well, in Singapore, we experience a dispute, in my experience, in almost every single project that turns up in Singapore. Whether it's a big project or small project, that it will inevitably be dispute. So sometimes they snowball into an arbitration. So what do we do to manage this arbitration? Now, one of the first things that I would ask is, okay. Okay, if we can move to slide 3, please. Slide 4, please. Yes. Now, I think one of the most important questions in any arbitration is, who is the arbitrator? And why is this important? Because the arbitrator determines your award, He determines how fast or how slow your arbitration goes. He determines effectively what are your solutions, what are the results that you get, and he also determines whether or not the arbitration effectively is a painful process or it's a smooth going process. So, and one of the key questions I always ask in Singapore is, whenever we have an arbitrator, and if the arbitrator appointed to a totally domestic dispute in Singapore is a foreign arbitrator, both counsel on our side and on the other side, we always ask, why is a foreign arbitrator appointed to a purely domestic dispute? Now, this often happens if we leave the choice of arbitrator to the appointing authority, which can be the institution, and in Singapore, it's the SIAC, and sometimes the SIAC does appoint a foreign arbitrator to a purely domestic dispute. And in such a situation, we must ask ourselves if this is even cost effective, because a foreign arbitrator will have to fly in, there will be travel expenses, hotel expenses. And while I say this, and when I speak on the arbitration clause, I also appreciate that in many situations, we are not in a position to negotiate on the arbitration clause, because if what you have is a tender and you tender for a project, what you will then sign on to would be the standard form contract, and you are unlikely to be able to negotiate on the arbitration clause. However, if you are able to negotiate the arbitration clause, I would suggest that you do so. Now, personally, if the arbitration was in Singapore, I would, number one, choose that the arbitrator would be a Singapore practicing construction disputes lawyer. First relevant prerequisite. The second one, someone around 20 years of experience, so that he or she would have been experienced enough to have seen enough construction and engineering disputes, and also be senior enough not to be perhaps overawed by counsel should they be more senior than him or her. Now, the next point that I raised might be a bit controversial in some jurisdictions, and I would say that I would also consider putting an age limit cap onto the arbitrator. Okay. I say this with some experience because there have been quite well, at least 2, if not 3 arbitrations which I've been involved in, where the arbitrator, perhaps due to age, perhaps due to other reasons, fell asleep during the arbitration. Now, the issue is, what would we do in such a situation? Do we confront the arbitrator, or do we say, sir, please wake up? What do we do? Now, in many situations, if I would suggest that while we all would like to say that construction disputes are exciting, the reality that it is not. It is drudgerous, it is filled with facts, it is document heavy. So imagine sitting through an arbitration filled with documents, filled with numbers, filled with drawings, and you are sitting down and it's heavy going even for counsel. So I would suggest that you, if possible, you put an upper age limit into the arbitration clause that you are comfortable with in respect of the arbitrator. Now, some jurisdictions might say that you might have to confront some employment statutes which prevent you from putting an age limit, or prevent you from stipulating ages in respect of the prerequisites to the arbitrator. I would suggest that, number one, an arbitrator isn't an employee of the party, so perhaps the employment statutes would not apply. Now, finally, if we simply leave the appointment of an arbitrator to the appointing authority, there is very little room to then challenge the arbitrator for bias or for any other reason, unless it is factually made out. And most of the time, if we do not include some prerequisites to the arbitrator, it may very well be that the arbitrator appointed to your dispute does not even have a construction dispute or an engineering background to your construction arbitration. So this is something that we should all bear in mind as a start to controlling how the arbitration is to go. We first need to look at our arbitration clause, and then we decide, number one, whether or not we are able to put some prerequisites as to who we want for the arbitrator, perhaps the institution that we wish to use, the SIAC, the AIAC, the LCIA, and also perhaps we resolve where the arbitration is to be held, the language of the arbitration, and certain other issues which you may want to think about. Now, if we can go to the next slide, slides. Okay, now, before the arbitration starts proper, I would suggest that in order to control costs and in order to prevent the dispute from further escalating, if possible, parties turn to mediation, but not just any mediation. In my experience, construction disputes do not lend themselves well to ordinary mediation. The mediation carried out has to be a mediation coupled with neutral evaluation. So this is generally different from general commercial mediation, because in a neutral evaluation, the mediator or evaluator will have to deal with the technical issues raised in the dispute. Now, again, who would I select as a mediator and a neutral evaluator? I would select an experienced construction lawyer, and more importantly, ask if the mediator or the neutral evaluator is prepared to do a prima facie merit analysis of your dispute. And on this point, I can only share an example of mediation cum neutral evaluation, which I participated in. As a young lawyer, it was a huge dispute. I think it was close to 100 million US dollars. So in-house counsel suggested that the parties start with mediation. Of course, as external counsel, we thought that this was such a huge dispute, it would be a waste of time, but nevertheless, parties went for mediation. They selected a very experienced barrister from the UK, and he was also prepared to do a neutral evaluation. So what happened was that he said that he wanted to hold the mediation over 3 days. And then before the mediation proper began, he sent a list of issues for each party to work out and to come back to him just prior to the commencement of mediation. The parties did not know what homework he gave to the other party, and so we set out to comply with his request. And just before the mediation commenced, we sent him all our answers, and when the mediation started, he made sure that there were 2 breakout rooms and there was a common room. So what he would do is that he would run between the parties, and then he would ask pointed questions. He will break down the issues. He would send us back to fulfill his request. He will then speak to the parties, their project team, in front of management, point out certain issues, point out certain weaknesses. And it all became not like a traditional form of mediation where literally the mediator just told you that, look, if you went for a full-blown arbitration, it'd be more expensive, you'll be spending time, costs, there'll be a lot of waste of money, time that is better spent in making in business. This mediation was a very focused mediation, and it coupled with a neutral evaluation. He was aware of all the issues, he was aware of all the counter arguments, and then he tested it in front of everyone, hearing what the project team had to say, and from the answers, he teased out the best solution for both parties. So at the end of it, while the parties did not settle every single dispute that was brought to arbitration, the arbitration did not go on because we managed to settle 90% of our differences. So that was in itself miraculous, because we all started thinking that this was a sheer and utter waste of time. But because the mediation was coupled with neutral evaluation, and the mediator was prepared to roll up his sleeves and actually do a deep dive into the facts, into the disputes, right? He focused the parties on the main issues, and we begin to see things in a different light. And I thought that was a very constructive mediation. In fact, the most constructive mediation conference that I have ever participated in. So if consider carefully, and I would commend this to you, mediation with a neutral evaluation. Of course, the person carrying out this mediation would need to have the relevant construction or engineering background, and preferably, in my own preference, would be an experienced construction lawyer. Perhaps we can have the next slide, please. Okay, now, if in general, most of our disputes and most of our standard forms will incorporate some form of institution arbitration rules. And this point is, in general, catches quite a lot of clients off guard. Now, for the purposes of Singapore and the SIAC, we have Rule 5, which speaks of expedited arbitration. In a nutshell, what expedited arbitration does is that from start to finish, your arbitration takes 6 months. Now, if you have not contracted out of this rule is in your arbitration rules if you use the SIAC, and for the purposes of Hong Kong, in the HKIAC rules, it is Article 42. So in Singapore, under the SIAC rules, if your dispute is in the region of 6 million Singapore dollars, then you are entitled to apply for an expedited arbitration. Now, all well and good. If we can turn to the next slide, please. So, if we can, yes, thank you. Now, as you can see, whether under the SIAC rules or the HKIAC rules, in the expedited arbitration process, the final award shall be made within 6 months. Now we ask ourselves, well, isn't a quick arbitration a good thing? Can I have the next slide, please? Okay, for those of us who have been doing arbitration for some time, let me just do a short calculation of what 6 months looks like. So say we constitute the tribunal on day 0. Then a month later, we have the statement of claim. A month later, we have the statement of defense. We assume that there's no counterclaim, and then we have a reply half a month later. We have discovery and exchange of witness statements. Perhaps half a month later, we have a hearing in a month. We have closing submissions in a month, and we have the drafting of what in a month. Now, anyone involved in construction arbitration will know that in the life cycle of a construction dispute, this is a very, very short time. So we ask ourselves, in 6 months, are you able to marshal your case? Okay. Is your project team even intact? Because we are assuming this project completed, say, 2-3 years ago, and the dispute only came about 2-3 years later. Is the project team around? Do you have to call them back? Are the documents already archived? Are they readily available? Do we need expert evidence? So is the 6-month time frame even realistic to muster your documents, engage experts, draft witness statements, and prepare for the hearing? My own experience in expedited arbitrations, unfortunately, has not been a good one. In general, and I speak from my own experience, clients are not, most clients in Singapore are not ready to have an arbitration thrust upon them that has to end in 6 months. And especially if you are the respondent, because the claimant may have prepared his a case perhaps 6 months ago, and then it's just launched upon you. So you don't have 6 months to prepare your case, because your statement of claim your statement of defense comes in 2 months. And if you are the respondent, you will definitely be on the back foot if your documents are not intact, your witnesses are not ready, and you haven't even found or have no idea where to find your experts. So this is something to look out for. If your institutional rules in respect of your dispute, it doesn't matter if it's in Singapore, Hong Kong, or somewhere else, contains a provision for expedited arbitration, consider whether or not the time frame in this expedited arbitration is suitable for disputes in respect of your project that you have signed on to, or perhaps for construction disputes in general. Okay, if we can go to the next slide. Now I will deal with some procedural devices found in institutional rules that can assist in cutting short disputes or in the early determination of certain issues that may be seminal to the entire dispute. It may be that you determine a single point, and then the parties look at it. If it's determined either way, parties will either give up the claim or feel that it's not worth going claiming thereafter. Now, so under the SIC rules, we have Rule 29.1, which talks about a party being able to apply to a tribunal for an early dismissal of a claim or defense on the basis that the claim is manifestly without legal merit, or the claim or defense is manifestly outside the jurisdiction of the tribunal. Now, there are similar provisions in the HKIC and the AIAC, which are the Malaysian rules. If I could have the next slide, please. Now, some of the issues which would be amenable for early determination would be issues like if a certain claim is subject to certain statutes of limitation, a time bar, or if certain claims have already been decided elsewhere, maybe in arbitration or maybe perhaps in court. Perhaps there are even clauses in the contract that limits your liability, and perhaps the claim is 10 million, but your limitation of liability is 1 million and you're prepared to pay off 1 million. You can even take out an early determination to say that if for taking all the claims at its highest, would my limitation of liability of 1 million, assuming I'm liable for 10 million, hold out, and if the tribunal says yes, and you're prepared to just pay off that 1 million and walk away, then that could be a solution to you. Now, for the purposes of the SIAC rules, I have used this device of early determination with some success. It was in the respect of a claim for variations, and concurrently, the claimant made a claim for the same set of variations under restitutionary law, okay, for unjust enrichment. And the law in Singapore essentially states that if the parties have a contract, then they would not have an alternative remedy in restitution. So what we did was that we took out an application for early determination that the restitutionary claims had no legal merit, and the tribunal agreed with us and struck out the entire restitutionary claim, which was quite useful to us because it narrowed down the work that we had to do, and the restitutionary claims fell away. So do consider if any of the claims or the defenses and that are made by the parties can be resolved quickly by way of early determination of certain issues or disputes, and thereby narrowing the focus of the arbitration itself, or perhaps even finally determining the entire dispute based on just a few clauses. Now, if I can have the next slide, please? Commencement of arbitration. Okay, now, in my mind, one of the most important persons once arbitration is to commence is a document manager. I always ask my clients to appoint a dedicated document manager to look out for documents, to marshal the documents, and to coordinate the search for documents on the client side. Okay, and effectively, this person will also liaise with the lawyers, with the experts in terms of documents. Now, why do I always request for this person? Because in my experience, project staff do not generally prioritize document requests over their normal work, because they look at an arbitration as something that historical, it happened so long ago, and the person asked to carry out the search may not even be involved in it. So there is, number one, no impetus in doing it. Number two, he has his normal project work that is probably urgent and he has to rush for it. And so most of the time, what happens is that they will do it when they are free to look for documents if he's not a dedicated document manager. And when he finds it, he will just give it to us as and when he finds something or the person finds something. And perhaps when it's really urgent and the management sits on him to do so, he suddenly dumps it all on us, and perhaps at the last minute. All this leads to stress on the experts, on legal representation, and also on the staff themselves. So a document manager would resolve all this. This document manager needs to be around perhaps at the very least from the start of the dispute where all the documents are to be marshaled, corralled, and then perhaps he can step up after witness statements are exchanged. So the period is not for the entire length of the arbitration, but just perhaps until witness statements are completed. I think this is the period that I think a document manager would be most useful. Okay, and for the next slide, please. Now, I think supporting your staff during the arbitration, this is one of the most important things that the management of any company can do if they're involved in an arbitration. In general, the project manager, contracts manager, or QS or other site staff, when they sign up for a job, most of them, or perhaps none of them, would have imagined that they will be saddled with an arbitration. So imagine if you are the project manager and you are involved in a dispute, and you are also having a portfolio of ongoing work. In the morning, you rush to the lawyer's office, you give instructions to your lawyers, to your experts. In the afternoon, you then rush to handle ongoing work, and you double head for long periods. And in our experience, staff who double head in terms of arbitration and carry out their normal work will not last long in the same company. So, and if I can have the next slide, please. So if, in general, if it's possible, the management of the company should consider a full-time redeployment of the staff involved in the arbitration until such time that the particular member is known, it's not needed on a regular basis. And this is important because we have experienced many arbitrations whereby the staff get worn out, they are tired from rushing up and down, and in terms of, and where it's hard to get good staff, these staff will then know that they are wanted elsewhere. You know, it's in Singapore, it's very difficult to get good project staff, and good project staff will leave if they double head for too long. And this will result in the loss of knowledge for the arbitration, loss of time in searching for documents. And then you may say that, look, we can simply subpoena the former staff to give evidence for us. Now, then the question arises, Would this staff give evidence willingly for you? Would they be an ill-prepared, reluctant witness? Will they even be supportive of your case? And will they even know what's happening if they're not prepared to come down and sit with you and understand and remember what has happened? I mean, perhaps they're just going to turn up and then they say, I can't remember anything. So it would be better if you have existing staff that were part of the project that's now going for arbitration. As far as possible, support them in terms of their workload and support them in terms of trying to take away their present workload to allow them to focus fully on the arbitration. Okay, now I will deal with the device, the process known as claim sampling. Now, in short, sampling, if we have 1,000 widgets and we are suing for 1,000 defective widgets, the question is, do I have to prove that those 1,000 widgets are faulty? And how much time and cost does it take to prove those 1,000 widgets to be defective and faulty? Can I pick perhaps 100 widgets and prove that they are faulty to be a representative sample of the entire 1,000 widgets, and would that save a lot of time and cost? And the answer in England and perhaps in Singapore is yes. The law and the courts are quite happy to accommodate sampling, and this is provided that on balance of probabilities, the samples are properly representative of the pool of allegations as a whole, so that the detailed investigation into the sample can be extrapolated into a result in respect of the pool. So this was Lord Justice Colson in the case of Building Design Partnership against Standard Life Assurance. Now, in the next slide, the courts in Singapore, if I have accepted the use of sampling in construction disputes. But what is important to note is that the courts in Singapore have made clear that sampling would be most useful to prove defects in standardized items. So perhaps you need to prove that 1,000 bolts are defective, or 1,000 nuts are defective, or perhaps 100 panes of glass are defective. So when we look at these standardized items, we can cut down on the work without having to review and analyze and assess each and every item by asking the tribunal for an order that the party or the claimant be entitled to sample a certain amount as evidence to show that the entire amount is defective. Now, one point to note is that sampling doesn't work when you have individualized claims, and defenses. So when the defects that you complain of are unique from item to item and there's no standardized process of construction, then sampling would probably not work in your case. Under the SIAC rules, Rule 19.1 and 19.2 would probably accommodate an application for sampling. And some other considerations in respect of sampling is to remember that we must make sure that our sample is properly representative, because if it's not properly representative, it's at the end of the day, your opponent manages to show that your sample size is not representative, then your entire claim will be thrown out. So in the case of Tyrannus Energy in Singapore, the fact that the expert did not go down to the site to personally collect the samples made his analysis bad. So bad and unreliable and inaccurate. And the court did not rely on the samples and found them to be that they did not prove what he wanted them to say. So when we pick a sample, we need to make sure that our expert signs off on the sample size and signs off that they are statistically significant. Okay, next I will now deal with the use of experts in arbitration. And experts, especially in construction arbitration, are very common. We have perhaps engineering experts, we have delay experts, we have quantum experts. So in general, in any one construction arbitration, you can meet one of perhaps 3 or 4 types of experts. So the first issue that I want to deal with is, should we use our own in-house experts? Now, I've discussed this at length with many fellow lawyers, and most of them come down to the fact that if you use your in-house expert, he will immediately be attacked on the basis of partiality. So in short, he's open to an attack that since you are employed by the party that you're giving evidence for, you will obviously give evidence in favor and you are not independent and impartial to the tribunal. Now, I will pause here and I will just ask you to consider that if your employee is the best in-house expert, the best technical expert that you know for this particular dispute, which concerns perhaps machinery or technology that you produce, that you are being sued on, and he has been using this technology for the past 10, 15, 20 years. He has commissioned more than 10, 20 projects using this particular technology, machinery, plant, equipment. And so I pause here to ask the question, how much time will an independent expert need to get up to the level of familiarity of your own employee with regard to this machinery and the dispute at hand? And I have used in-house experts before, and in general, when the choice is between an in-house expert and an external expert, I always find reasons to exclude the in-house expert as opposed to find reasons to include him. Because if the evidence he is giving is mainly technical and can be tested through cross-examination and is based on empirical evidence, is based on facts and figures, is based on what was carried out, is based on something that can be tested on cross-examination, and this is in your favor, to what extent will this be outweighed by the fact that he is your employee and there is a veneer of impartiality? So the bottom line is that if he's telling the truth and he can prove it technically, why shouldn't we use this person? And in my view, we should seriously consider using this person instead of somebody external. Number one, quite apart from saving time and cost, he is really the best person for the job. So if all things considered, all other issues or all other relevant considerations are equal, I would use the in-house expert. So for me, the in-house expert on the basis of partiality, is it a definite no? I would answer that definitely no. I would use the in-house expert. Okay, now the next issue I want to deal with is managing expert evidence. And this point arose from an arbitration I was involved in, whereby a very experienced arbitrator who also happened to be a construction lawyer, actually, when it came to the expert evidence and expert reports, he actually sat down for half a day, sat the parties down for half a day, and he made the parties come up with lists of items that each expert was supposed that each expert wanted to give. So we were supposed to give him headers and subheaders and subheaders, and I think we broke it down to 3 levels. And then we were supposed to exchange this list and then we see whether or not we can come up with a common title for everything. If not, he would resolve it. And he sat there for half a day with us and the experts, and literally we came up with a list in respect of the titles and subtitles of the entire expert report. So at the end of the day, both parties would go away literally just to fill in their opinions underneath all the titles and subtitles. And so when you went to look for what expert A said in respect of something, you would just have to look at the same subtitle in respect of expert B, and you didn't need to hunt for what his opinion was all over his report. So we could literally compare them apples to apples. And I recall in those days where I still printed out expert reports, I could tear off the sheets because he also asked for each new title to be on a new page. So when we printed everything out, every new topic was on a new page. And when I compared what each expert said in respect of a particular item, I could literally rip off the pages from what was stapled to compare them side by side. And to me, that was cut down a lot of time in terms of hunting for where one expert said and what the other expert said on the same point. And it made life very clear. And he also said that, look, he wanted certain tables, got schedules. And so the arbitrator literally managed the presentation of the expert evidence. And it was so useful at the end of the day that I'm not sure why more arbitrators are not using it today. So on this point, once we have experts, the first thing that we do is that we bring them together, and legal counsel on both sides for both parties can come together and see whether we can agree on a framework for the parties to meet, to see whether we can agree, the experts rather can agree on certain items. And if they do, these items don't even need to be addressed. Now, the format and the issues, I would suggest some agreement so that when the parties present their expert reports, they look similar in terms of presentation, if not identical. Of course, the content would be different because there will be different opinions, but where certain opinions are to be found must be on the same area, the same page, the same subtitle. Now, so now we have the expert reports and they have been exchanged. The next question is, would a post-expert report exchange meeting further narrow the dispute? And if so, then the parties should meet. And if not, then we can do away with that. Now, one of the best devices in the course of the arbitration hearing to cut down in terms of cross-examination and re-examination of expert witnesses, in my experience, is hot tubbing. Now, hot tubbing is a procedure whereby both witnesses are placed together at the same time, and either a list of questions are asked of them by the tribunal, by counsel for other parties, and they will just give their answers on the spot. And if the answer doesn't is to be contradicted by the other expert, it is done on the fly. You don't wait for your turn after cross-examination of the witness and you come back and you answer it through re-examination by your counsel. It is done on the fly. So of course, when one person finishes speaking, then the other person just jumps in immediately after. There will be no loss of focus and the point is clarified immediately. So in my experience in hot tubbing actually does away with a lot of re-examination by counsel. And in fact, if both parties agree to allow the arbitrator free hand to ask his questions, then he will just ask his questions to clarify any doubts and any queries he might have in respect of both sets of opinion, and it ends there. Of course, counsel should reserve the right to raise any questions flowing from the arbitrator's questioning, but hot tubbing, the simultaneous provision of evidence, is really a very useful tool in managing expert evidence, and also it makes very clear the important points in respect of the expert evidence, because when there is a disagreement, it surfaces immediately. Either one party agrees or they disagree, and they chime up and they identify why they disagree with it, and they justify it on the spot. So it is fast, it clears up the point quickly, and people don't lose their trend, as opposed to have you to wait for your cross-examination, your re-examination, and wait for the other witness to then try to explain what had taken place the day before with another expert if hot-tubbing had not been carried out. And with that, I think we have come to the end of my presentation. We have about, I think, perhaps 15 minutes for some Q&A, and so I will invite questions from the participants. Can we get...
Thank you very much, Tian. And just before we move to our Q&A section, I would just like to say thank you very much for that incredibly informative webinar, looking at the landscape of construction arbitration in Singapore. Very, very interesting. So we will move now to our Q&A. We've got some great questions in already, but please do, if you have a question, please do send it in. And
okay, yes, I see some questions. I'll deal with the first one. Okay, I think the question asks, for projects smaller in size than 6 million Singapore dollars, is it considered a complex construction arbitration? Now, I think the issue is not really about the size of the dispute. It's really what efforts you will need in order to marshal your evidence and your resources to meet the claim. So while the amounts might be small, proving your claims might be complex. So the complexity is in terms of the proof and not so much in terms of the dollar amount, because the dollar amount might be big, but the complexity in proving it might be small. So when I speak of complexity, I'm talking about the process in which you need to go about proving your claim or defending your claim. Okay, let me see. Can I go down to the next question? The next one? The next one? Okay. Now, okay, the question is, does SIAC maintain a separate list or panel of specialized or experienced construction dispute arbitrators? I think as far as I know, they do not have a separate listing, but when you are empaneled as an arbitrator for the SIAC, you set out your expertise and then you set out what you're prepared to take. So if you're prepared to take admiralty or marine arbitrations or construction arbitrations, corporate commercial, you will set it down in your CV. And so the answer is, I don't think they do have a separate list, but internally they may maintain this list that is not apparent to the outside world. Okay, there is another question which asks, would Singapore courts admit petitions objecting to the constitution of an arbitral tribunal on the basis that arbitrators are not experienced construction dispute arbitrators? Okay, the short answer is yes, they would entertain this, but the practical answer is that how will you prove that this person is not an experienced construction dispute arbitrator unless you have made it quite clear in your arbitration clause the minimum criteria in which this person might pass. So for example, you might say that the arbitrator to be appointed must have heard at least 5 construction arbitrations, or have been counsel for at least 5 construction arbitrations or 10 construction arbitrations. In Singapore, I mean, one way of ensuring that I suppose you get an experienced construction lawyer to be arbitrator is to say that you would wish to appoint a senior accredited specialist in building and construction, and so that just limits it to those who have been appointed as such, you see. So I hope that answers the question. Okay, so there's a question which is asked, how can discovery or interrogatories be used effectively? Okay, so first of all, when we talk about discovery and interrogatories, it also depends on whether you come from a civil law or common law tradition. So, and also depends on your arbitral rules. But in general, I think if we are speaking about the SIAC rules, the SIAC rules require you to put all your documents that you intend to rely on already inside your points of claim, so that will support your claim. So in theory, everything that supports your claim would already be in. Now, in construction arbitration, and especially if you need to, for example, analyze or you need to carry out delay analysis, then contemporaneous correspondence is very important. So what then happens is that you will need as much documents as you have or as you can get your hands on in order to reproduce the critical path. So in that case, then I guess you would then apply to the tribunal for documents that are in the possession and relevant to your claim to be disclosed by your opponents. So in that sense, yes, discovery is a very important tool in the arbitration arsenal. Okay, we now have a question also on the costs of arbitration. Okay, now, so when we talk about the cost of arbitration, there are the cost of, I guess, starting the arbitration and the cost of the institutional cost of the arbitration and how much the arbitrator can charge is normally found in the websites of most major arbitral institutions. They probably have an online calculator which allows you to input your amount in dispute, and then they will come out with a fair estimate. In respect of the rest of the costs, I guess that depends on the lawyer that you choose and experts that you engage for the process. But in terms of the institutional arbitral costs and the cost of the arbitrator itself, these are easily found on most institutional websites. Okay, let me see. I think I may have gone through most of the questions. Is there any other question that I have not dealt with?
There was one question, and correct me if I'm wrong, Tian, if you did answer this question. It was a follow-up from Druva from the first question.
Okay, let me look at that. Okay.
And that question is how damages are defined in Singapore.
Okay. Let me take a look at it. Okay. Now, in general, when you have a can you just stop that? Yeah. Okay. In general, when you have a construction project, it would mean that you have a construction contract. And if you have a construction contract, right, then your damages that you claim are in general compensatory. So if we are talking about restitutionary damages, then under Singapore law, if you have a contract, you will not be entitled to claim restitutionary damages, which would be a claim outside of the contract. So, and compensatory damages are just damages that will compensate you for the loss arising out of the contract as though the contract had been performed. So I hope that answers the question.
Thanks. And we've just had a new question come in, Tian.
Yes.
At the bottom of that list.
Okay, now, so the question asks, how detailed should closing submissions be in construction arbitrations, and what should be the main points of focus? Now, that's a very good question. And the first point that I would say is that you need to take your cue from the arbitrator, because in the course of the arbitration, if you look at your arbitrator carefully, he would drop hints by way of body language, by way of certain things that he says, what he's interested in, what he is concerned with, you know, and then you should note those down because it means that you need to deal with those points. Okay. Now, then there will be some issues where it's very clear to him, and if it's clear to him, it should be clear to you as to what he's clear about. He's either clear that you don't have a case or he's clear that you have a case. And if you really have a case, I would not deal with those issues too much because the arbitrator has already understood whether or not you have a defense or a good claim on that point. Deal with those points. I wouldn't say comprehensively, but deal with those points logically and sensibly, because if he's with you, you do not need to flog the dead horse. Okay. Now, in respect of the issues which you need to really focus on are those issues that I suppose, number one, are big ticket items. Number two, they are somewhat during the hearing, he's not really convinced of your case, or he's not really convinced, or perhaps he asked certain questions which shows that he's unclear in certain areas and maybe they were not even clarified during the hearing. Deal with those in more detail, you know, and in general, I would say that when you do closing submissions, use more tables, bullet points, and make your submissions short, because most arbitrators do not want to read long sentences, especially if they're technical. And if you can make the point in one sentence, don't make it in two. You can make the point using existing evidence that's caught during cross-examination. That is even better because you're making the point using your opponent's evidence rather than you explaining it again. Make the point using contemporaneous evidence, and make the point using, even if, say for example, if the arbitrator made an explanation, yeah, I thought that was the point, you can even flag that and say that even the learned arbitrator raised the point and saw the point during cross-examination, you know, something like that, to just remind him that it was quite clear to him at the point. So in terms of closing submissions, I think you need to, there is a lot of culling to be done, because we all tend to say more than we should, and we just focus on the important points, those that we are fairly clear on that we will definitely win. Just make the point and move on. We don't have to flog the dead horse.
Perfect. Thank you, Tian. We've had another question come through from Niram Janet, and I think after we answer that question,
okay. Well, I can only answer this in the context of Singapore. Now, can a reluctant former employer be compelled to attend an arbitration hearing and to provide evidence? And what happens if the employee has relocated to another country? Now, if the former employee is still in Singapore, then you can issue out a subpoena to compel this person to attend the arbitration. Now, because subpoenas are only jurisdictional and a Singapore court can only issue a subpoena in Singapore, you cannot issue a subpoena to compel somebody outside Singapore to give evidence. What you can do is that you can try to convince that person to give evidence by video link, and you probably need to seek permission from the tribunal to do so. Now, if the former employee chooses to voluntarily travel to Singapore from a foreign country to give evidence on behalf of the company, then I would imagine that would be ordinary expenses of the arbitration that you can claim against the other party should you be successful. So the answer in short would be a yes. Okay, any other questions?
Perfect. I think that's it, Tian, and just looking,
okay.
We're a minute to the hour. So I'll hand over to you, Tian, for any closing comments and to thank you.
All right. Now, perhaps I should just take the last few minutes to introduce the firm. I started in the big firms, and I decided to start my own practice, essentially because of conflict issues. So essentially, we are a conflict-free firm. There are many big firms that can't act against bigger boys in Singapore and the region due to existing legal relationships, and most of them may not want to act against statutory bodies or the government. So, and in general, that's where we come in to take on such work, and we also act as conflict lawyers for many of these larger firms. So if after this session anyone has any query, do contact me directly. My email address is I think on screen. So, and it just leaves me to thank everyone for joining us today for this webinar. Thank you very much.
Thank you, Tian. Thank you, everyone, for joining. Have a lovely rest of your day.
Thank you.